Hello! In this clip from our Justia webinar, Sarah Frug and Craig Newton, co-directors of the Legal Information Institute at Cornell Law School, will talk about copyright and its relation with primary legal materials. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Thanks, Sarah. I'm going to switch gears now and talk about copyright as it relates to primary legal materials and related texts that are certainly helpful and perhaps necessary to interpreting them. First, it's important to note that there's actually no copyright in anything produced by the federal government. And for the longest time, LII mostly published just federal materials as well as our own original content, which meant copyright concerns weren't a big part of our work. But as you know, federal law only rarely covers the entire field when it comes to what we call the law of where I'm standing right now. And in recent years, we've become more interested in and more capable of moving down the jurisdictional stack, at least as far as into the states, where copyright becomes an issue in ways I'm going to explain today. Claims of copyright in primary legal materials and related texts people need in order to interpret or even understand that black letter law raises challenges to what we can publish, whether we can publish a comprehensive set for all 50 states, and the extent to which we can design and implement technology to aid our work. In other words, what's ultimately available to you as the end user of legal materials online. Your written materials today include key orders in these 5 cases. I'll start with Georgia v. publicresource.org. This is a 2020 U.S. Supreme Court case. If you don't know PRO, it's the work of a man named Carl Malamud. After he won the Court of Appeal, he joined Georgia's cert petition to have the Supreme Court hear the case because he said he was in search of one rule that applied everywhere in the U.S. instead of just a victory in the 11th Circuit. In this case, the legal materials in question were the Official Code of Georgia Annotated, or the OCGA. Georgia's Code Commission is an appointed body comprised largely of members of the Georgia legislature that is responsible for promulgating the OCGA. The commission hires a commercial vendor, in this case LexisNexis, to create the annotations following a very strict and detailed set of instructions about what to include and what not to include. Then the legislature votes to merge the annotations into the code and then to adopt the merged annotated code as the official code of Georgia. There is no official unannotated code in Georgia like there is in most, though it turns out not all of the other states. Georgia retained the copyright, but allowed the vendor to monetize the OCGA by selling copies and by allowing it to be the exclusive online publisher of the OCGA. In exchange for the right to monetize the OCGA, the vendor did not charge Georgia to create the annotations. Georgia did make available online for free an unofficial, unannotated copy of the Georgia Code. So what was in dispute was the applicability of something called the government edicts doctrine, which has its roots in 3 cases from the 19th century. In the 1834 Wheaton case, the court held that, quote, no reporter has or can have any copyright in the written opinions delivered by this court, and that the judges thereof cannot confer any such right, end quote. Banks from 1888 is probably the most important to the Georgia v. PRO case. It applied that Wheaton rule to state courts, holding only that, quote unquote, authors could hold copyrights, and that neither a judge nor a reporter of decisions could be the author of a judicial opinion for the purposes of the copyright statute. Callahan decided just a few months after Banks sort of went the other way by holding that the official reporter of decisions for the state of Illinois did in fact have copyright in the portions of the volume of the decisions that were, quote, the result of his intellectual labor, unquote, such as headnotes and other annotations. The question before the Supreme Court in the PRO case then was how the government edicts doctrine applies to legislative materials, especially annotations and other materials that arguably do not carry the force of law, but are instead only supplemental or explanatory in nature, especially where those materials were not created by the government itself, but rather by a third party at the behest of the government. The trial court initially agreed with Georgia that the annotations were subject to copyright because they did not carry the force of law. PRO appealed to the 11th Circuit. The Court of Appeal reversed the trial court and articulated a 3-part test. That opinion is included in the written materials. These are quotes from that 11th Circuit opinion. In all of these slides, please pay particular attention to the text that's not in black. There was no dispute that the actual laws themselves are not subject to copyright. Once again, the court's task was to apply the government edicts doctrine from the 19th century to this situation. namely the commercial annotations for hire that were later merged with the actual laws and adopted as the official code for the state of Georgia. Banks was the case where the U.S. Supreme Court said that state judicial opinions, like federal judicial opinions, could not be subject to copyright. The 11th Circuit said Banks was not especially clear on the reasoning for that rule, but it understood the rule to derive from first principles of democracy, namely the sovereignty of the people. They said, quote, you see at the bottom of the slide, quote, when the legislative or judicial cords are plucked, it is in fact the people's voice that is heard. The appellate court went on to say the general rule that legislative codifications are uncopyrightable derives from an understanding of the nature of law and the basic idea that the people, as the reservoir of all sovereignty, are the source of our law. And down there in the corner of that slide is a screen cap of an old video we made around 2012, in which LII co-founder Peter Martin is saying this very thing and explaining why we and others like us do what we do. The Court of Appeal continued, because our ultimate inquiry is whether a work is authored by the people, meaning whether it represents an articulation of the sovereign will, our analysis is guided by consideration of those characteristics that are the hallmark of the law. In particular, we rely on the identity of the public officials who created the work, the authoritativeness of the work, and the process by which the work was created. You'll see in a moment why I color-coded those 3 bullet points. But that was the appellate court's 3-part test to determine what materials are copyrightable versus which belong to the people as the reservoir of all sovereignty. And here's its own summary of what it ultimately decided after a thorough analysis of its rule. The purple's the identity, the green's the authoritativeness, and the pink is the process, all of which led to the conclusion that the OCGA was not copyrightable. As I said, this went to the Supreme Court at the request of both parties, and it said, we affirm the Court of Appeal, but for a different reason. The opinion by Chief Justice Roberts is in your written materials. As you can see from the visual representation of the vote provided by oye.org, the case was not decided along ideological lines. Instead, it appears age may have been a factor. The 5 justices in the majority were the 5 youngest, all under 60 at the time. The 4 dissenting judges were all over 60 years old at the time. And I believe that's significant for reasons I'll explain in just a bit. The court said, in effect, this is straightforward based on the identity of the author. Judges and now legislators cannot be authors for the purpose of the copyright statute when they are working as judges or legislators. So going back to my obnoxious color coding for a second, here's a comparison of the rule articulated by the Court of Appeal and then differently by the Supreme Court. But I think when viewed side by side like this, it's easy to argue that there's not much difference between the two. The court said, and forgive me for reading again, because judges are vested with the authority to make and interpret law, they cannot be the author of the works they prepare in the discharge of their judicial duties. The animating principle behind this rule is that no one can own the law. Every citizen is presumed to know the law, and it needs no argument to show that all should have free access to its contents. Now, in the corner of this slide is a screen cap of that same 2012 video in which LII's other co-founder, Tom Bruce, is saying pretty much the same thing. So I think it's not the rule that differs from the 11th Circuit's opinion so much as the reasoning behind it. The Court of Appeal relied on sovereignty of the people with a capital P, so to speak, while the Supreme Court relied on the premise that we are all presumed to know and understand the law, more of a due process reasoning, if you will. Now, several slides ago, I told you that the trial court sided with Georgia that the only thing a state government can't copyright is a thing that carries the actual force of law. And Justice Ginsburg dissented on that ground. The court's majority said if force of law mattered, states would own the non-binding legislative materials produced by legislative bodies acting in a legislative capacity and could charge the public for access to them. If everything short of statutes and opinions were copyrightable, then states would be free to offer a whole range of premium legal works for those who can afford the extra benefit. A state could monetize its entire suite of legislative history. With today's digital tools, states might even launch a subscription or pay-per-law service. Now, I just skipped some stuff in the middle of that opinion, so I'm going to expand out on those ellipses now. Now, as you read this expert, which I'm not going to read out loud, I'll explain that one of the many conditions that Georgia imposed on its vendor was that the vendor had to make a physical copy of the OCGA available in several libraries across the states. I think it was around 60 libraries. Georgia, of course, pointed to that as adequate public access such that anyone who really needed to read the law in Georgia could go to a library if the unofficial, unannotated version it put online wasn't good enough for their purposes. The Court of Appeal dealt with that argument in a footnote, saying that 60 libraries for 10.5 million citizens of Georgia was insufficient public access. The public domain is the public domain, and you can't restrict that, the court said. The Supreme Court ignored the library copies altogether. There's literally no mention of them anywhere in the majority opinion. Bad news for the librarians out there, perhaps, but wonderful for those of us who put laws online for free. The Chief Justice of the United States addresses only online access, presuming that, quote, a Georgia citizen interested in learning his legal rights and duties, end quote, will go online to find out what those are. And here's why I said before that I think the ages of the justices influenced their reasoning in this case. The 5 youngest agreed, first, that ordinary citizens will go online to learn their legal rights and duties. And second, right there on the internet, they're entitled to find that information, not the economy class version, but the first class version, in the words of the Chief Justice, for free. At the beginning of this webinar, I showed you this slide with the top of the LII homepage on it, and I said a few words about how in 1992, it wasn't a foregone conclusion that the world would ever see online legal materials as authoritative. And 3 decades later, there's the Chief Justice of the United States just sort of assuming that the public will go online to learn about their legal rights and responsibilities. That must have been a very satisfying moment for our predecessors in the free law movement, who heard many, many times throughout those early years that the law was far too serious for something as frivolous as the internet. And now I know our agenda for today says we're going to talk about ramifications at the end of the presentation, and we will, but I'm going to cheat a little bit and give you a real-world illustration right now of what the Chief Justice was talking about in that last quote, where he mentioned some important laws a person wouldn't know were no longer valid if they didn't have free access to the Georgia Code annotated, because old laws aren't always taken off the books. Turns out that non-persons like ChatGPT have that problem too. This is a slide I borrowed from a presentation I saw Justia CEO Tim Stanley give in June. He asked ChatGPT this question about same-sex marriage in Mississippi. As you can see, it told him that same-sex marriage was still illegal there. And why did it tell him that? Because the version of the Mississippi Code that the state makes available online still shows that law in the books. So, like Sarah's example about the stars on the American flag, this shows why materials have to be really complete, and maybe just not in one collection, but across collections before you or ChatGPT can find the right answer. And lack of completeness can be a problem that can either be policy-based, like refusing to go back and formally repeal antiquated laws, or it can be technical, as Sarah made clear. And of course, those technical problems can exist at any point in the process, from the legislature or government agency that is the original author of the work product, down to the state employees or hired vendors who create and mark up the digital version of that work product, all the way down to an online publisher, whether it's us or someone else, whose software fails to detect a change and implement it because of something so small as the wrong kind of dash having been used in the computer code somewhere along the way. The last thing we need to pause on from this case is what the court said about copyright and fair use. It noted that copyright is presumptive and adheres automatically. And if every time someone wants to share the law, they have to first violate a copyright and then defend their actions as fair use, that is, in the words of the court at the bottom of the slide, notoriously fact sensitive. In the end, the court said, we're going to make a rule that says because the public is presumed to know and understand the law, state legislatures cannot be authors under the copyright statute of materials that are key to that knowledge and understanding, such as the Georgia Code annotated. This isn't about fair use, because fair use, especially in a case about our ability to communicate about the law, is messy, inefficient, and a last resort. But what about when the law contains text authored by a private entity? These three very similar cases in the red box are among those at the forefront now of copyright in the law, and they don't speak to the same scenario as presented in Georgia v. PRO, but instead deal with incorporation by reference, which courts in DC, New York, and California so far have all agreed falls outside of the government edicts doctrine, but have found Georgia v. PRO to provide important guiding principles, which is why we just spent a lot of time on it. In each of these three cases, there are private organizations that have created industry standards or model codes and copyrighted them, and then governments up to and including the federal government have adopted them into law through incorporation by reference. As Sarah mentioned, Congress has explicitly encouraged this practice at the federal level, and she showed you an example or two of that in action. My example, and I didn't choose this example, the DC Court of Appeal did, is 46 CFR section 39.2009, which you see on the slide says you can power your barge's liquid overfill protection system by hooking up to an off-barge facility so long as your explosion-proof plug conforms to Article 406.9 of something called NFPA 70, which is a copyright-protected standard owned by the National Fire Protection Association, or NFPA. But you'll note that the regulation doesn't actually say what expressly Article 406.9 of NFPA 70 mandates. You have to go to the NFPA for that, and they want your money so that they can continue to gather experts who debate the merits of the various possible features of explosion-proof plugs for liquid overfill protection systems. And that's not an inherently bad thing, right? We want to create incentives for experts to do this work and keep us all from buying shoddy explosive-proof plugs for the various liquid overfill protection systems we use in our myriad barges. And that's well aligned with the purpose of intellectual property law generally. The defendants in these incorporation by reference cases, the folks publishing these standards that have been incorporated into the black letter law by reference are, once again, Carl Malamud's nonprofit, publicresource.org on the left, but also a for-profit creator of compliance software called Upcodes. That's part of their website on the right. In all these cases, the defendants were accused of reproducing entire model codes or whole chapters of model codes or other quanta of the codes that sometimes went beyond what could be shown to have been clearly incorporated by reference by one or more jurisdictions. The various courts that have handled these cases have usually seen fit to organize the model codes by those that have been clearly incorporated by reference into black letter law and those that have not. All of these cases have the sort of classic cascading dog bite defense along the lines of, I don't have a dog. If I do have a dog, it didn't bite you. If it was my dog that bit you, then you provoked it. In this context, it goes something like, first, Georgia v. PRO and the government edicts doctrine applies. If not, then the plaintiff's materials are now in the public domain. And if not, then the copyright defense of fair use applies. The first of these three incorporation by reference cases is ASTM v. PRO and is 10 years old now. As you can see from the bullets, the trial court originally sided with ASTM in an early motion for summary judgment. In 2018, the Court of Appeal reversed and remanded, instructing the trial court to start over and conduct a full fair use analysis on a completely developed factual record. In that order, it punted on passing judgment on PRO's argument that these standards had passed into the public domain. After characterizing that claim as voicing, quote, a serious constitutional concern with permitting private ownership of standards essential to understanding legal obligations, end quote, it explained it would, quote, leave for another day the question of whether the Constitution permits copyright to persist in works incorporated by reference into the law, end quote. It explained that while it's easy to say the law cannot be copyrighted, it's far more difficult to determine whether an incorporated standard has actually become the law. And that's because the way governments incorporate these standards by reference occurs on something of a sliding scale. There are what these courts seem to think are fairly easy cases where a jurisdiction cites a standard by chapter or section number and says, this is the law of our jurisdiction. And these model codes often include everything a jurisdiction needs to do that, including civil or even criminal penalties for violating them. But there are also circumstances like the explosive plug example I gave you before, where the government says you have an obligation, look at this private standard for the scope of that obligation. And courts and litigants involved in these cases have tried to draw a distinction then between when text incorporated by reference creates a legal obligation versus when it merely defines the exact contours of an obligation that the state has imposed. As you can imagine, that is not a great topic for summary adjudication. Moving to the third bullet of this slide, after the Court of Appeal remanded the case for a full consideration of fair use upon the close of discovery, the trial court on March 31st, 2022, published a 47-page order denying ASTM's motion for summary judgment, and also a 187-page index or appendix in which it went through a full fair use analysis for each and every ASTM standard alleged PRO had published in violation of ASTM's copyright. That order and appendix are in the written materials. Now, just 3 years and 3 slides ago, the Supreme Court said, hey, it would be great if we could avoid questions of copyright fair use when it comes to folks who want to talk about the law. But here we are. Of course, one wonders if the Court of Appeal would have deferred the public domain question and leaned on fair use in its 2018 order if it had been in possession of a crystal ball that would have shown at the Supreme Court's pronouncement 2 years later that fair use was not the way to go. But the timing is such that it created this funny loop where the ASTM trial court is responding to an order from the Court of Appeal requiring it to do this elaborate fair use analysis where there's intervening dicta for the Supreme Court, which cast doubt in the viability of fair use to do the heavy lifting in these cases. In any event, ASTM's appeal of that MSJ denial from March of 2022 is fully briefed and argued at the 11th Circuit, and we'll see what happens next. The next case, ICC v. Upcodes, is actually 3 cases, 2 alleging copyright infringement and 1 alleging false advertising, which have now been consolidated and are in the discovery phase in the Southern District of New York. You have in your materials a May 27th, 2020 order denying the parties' motion for summary judgment in their original copyright case, which dates back to 2017. And the order is quite remarkable in that it goes where the DC Court of Appeal was unwilling, holding that anything plaintiffs created that has subsequently become black letter law through incorporation by reference is now in the public domain. It doesn't dispose of the case, however, because the plaintiffs allege that the Upcodes website contains copyrighted materials that were never incorporated by reference into black letter law anywhere. So in addition to the public domain analysis, there's also a lengthy fair use analysis. The court finds that even if ICC's copyrighted materials that were incorporated by reference into black letter law are not in the public domain, Upcodes' use of them is fair use. As for additional materials belonging to ICC that Upcodes has allegedly placed on its website but aren't part of the black letter law anywhere, the court holds that it cannot rule on the record before it whether or not those extra materials amount to, in essence, a sort of legislative history that is sufficiently related to understanding the incorporated codes that its reproduction by defendant is fair use. These are materials like red lines showing which text a particular jurisdiction chose not to adopt, for example, where seeing that might help a reader better interpret or understanding vagaries in the language as adopted. Now, the third case from which we've included an order is NFPA v. Upcodes, and it's a little different because it comes at the preliminary injunction phase, and therefore the standards and burdens are different, and the court's goal, so to speak, is also a little different, right? In a relatively short order, then, the court was able to rule that fair use creates sufficient questions of fact on whether or not the plaintiff will prevail, such that it could both A, deny the motion for PI, and also B, punt on the other questions raised about the public domain, due process, etc. So let's take some time to talk about fair use in a little more detail. Traditionally, and in its simplest form, fair use pretty much comes down to money. Is the infringer making money and is the copyright holder losing money? Of course, it's a little more complicated than that, but perhaps only just a little. So maybe some of you noticed that I made a point of noting that PRO is a nonprofit entity, while the other defendant in these incorporation by reference cases, Upcodes, is a for-profit company. One thing to keep an eye on is if and how that influences the fair use analysis these courts and probably their appellate courts will ultimately do. But really, these incorporation by reference cases will probably hinge on the doctrine of transformative use. First, you'll notice this phrase does not appear anywhere in the actual statute on the right side of the slide. In short, the more transformative the use, the less the distinction between commercial and not-for-profit is going to matter, and the more likely a fair use defense will prevail, almost regardless of how the whole four-prong analysis otherwise goes. In other words, even though transformative use analysis typically nests under the first factor of purpose and character of the use, as you see on the slide, it seems to have a way of informing the entire analysis. I can't think of a single case I've seen where a court found a use to be transformative, but in light of the other factors, still refused to find fair use. Transformative use is a concept that the Supreme Court introduced to the world for the very first time in 1994's Campbell v. Acuff Rose Music, the Campbell being Luther Campbell of the infamous rap group Two Live Crew, infamous at least in my house growing up anyway, and the transformative use in question being a parody of Roy Orbison's song, Oh Pretty Woman. In the 2015 case, Authors Guild v. Google, the Second Circuit ruled that Google did not violate copyrights when it scanned whole books so that users of its Google Books and Google Library Project search engines could find words or phrases in those books that were interesting to them. The Google search results would even include small snippets of the copyrighted works that were relevant to the user's search inquiry. The Second Circuit said, quote, "We have no difficulty concluding that Google's making of a digital copy of plaintiff's books for the purpose of enabling a search for identification of books containing a term of interest to the searcher involves a highly transformative purpose in the sense intended by Campbell," end quote. So that's a case where even though many of the copyrighted works were highly creative, the second factor, and Google copied the entirety of the work, the third factor, the purpose of the copying was so transformative as to predominate over the entire fair use analysis. The Supreme Court didn't take that one up, denying cert in 2016 and therefore leaving undisturbed the Second Circuit's ruling in favor of Google. The court did tackle fair use, coincidentally with Google once again as a defendant 5 years later. The Supreme Court ruled that Google's copying of the Java APIs, which were copyrighted by Oracle, was fair use. The court said, first, Google's use of the Java's API was transformative because the copying allowed programmers to work in a different computing environment, but with a familiar programming language. Second, the copied lines were, quote, inherently bound together with uncopyrightable ideas, end quote, suggesting it was unlikely to undermine the general copyright protection that Congress provided for computer programs. Third, Google copied only 0.4% of the entire API. And last, the record showed, according to the court, that Google's new smartphone platform was not a market substitution for Oracle's Java-based product, Java SE. The dissent noted the large financial stakes implicit in this copying, the question of market substitution notwithstanding, but the majority was unfazed by that. Now, we'll come back to transformative use in just a minute when we discuss ramifications for the future. But before that, I want to talk very briefly, about Thomson Reuters v. Ross Intelligence. TR is the parent company of Westlaw. Way back in 2017, they noticed unusual usage patterns by a licensee called Legalese, who is basically a litigation support company. TR sued that licensee for violating the terms of that contract and quickly realized that the company was doing what it was doing because it was handing over tons of case law to its own client, Ross, a Canadian company that has visions of revolutionizing legal research using AI. On the slide is part of Ross's website there. TR settled that first lawsuit with Legalese and then sued Ross, alleging, among other things, that Ross's use of Westlaw's case law violated West's copyright in its key number system and its head notes, etc. In due course, Ross answered and counterclaimed. Those counterclaims included allegations that TR's refusal to license just Westlaw's case collection without access to the Westlaw software platform itself and what Ross calls Westlaw's quote-unquote search technology violates sections 1 and 2 of the Sherman Antitrust Act. West moved to dismiss those counterclaims, but the court denied that motion, and you have that order in your written materials. Here's a summary of some language from the court's denial of TR's motion to dismiss in April of 2022. The citation at the top of the slide is to that order, and the citations in the bullets are contained in the court's order, lest anyone accuse me of doing the slightest bit of my own analysis on the merits here, because I am not now, nor have I ever been, an antitrust lawyer. Basically, Ross's relevant allegations, the court identified, are that TR doesn't separately license its case law from its search tools, but that because of its dominant market position, TR needs to do that for antitrust purposes because, Ross alleges, the market for just the case law that TR owns is distinct from the market for the whole Westlaw enchilada. Ross has also alleged that TR's take it or leave it Westlaw user contracts don't allow those licensees to only use what they want, and then TR takes advantage of the existence of their copyrighted headnotes and the key number system, etc., to sue anybody that tries to republish or otherwise creatively use just the case law. Now, in his April 22 order denying TR's motion to dismiss, the court found that the facts Ross pled support theories of liability under sections 1 and 2 of the Sherman Antitrust Act because they allege an illegal tying of the case law database itself to West Search Tools and the Westlaw Research Platform. In June of 2023, TR purchased a company called Case Text, which was a competitor of Ross's in the legal-powered AI space, who was able to jump ahead over the last couple of years as Ross shut down operations to focus on this litigation, which is a really interesting twist on all of this.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.